way to start this afternoon session. I was here in January for the inauguration, and I came over with my family, and it was the second time I'd been to the Museum of the Bible and for a tour. And there's so much to see, you don't see everything on one tour. But we had this story about a very unique Bible, and I wanted them to tell that story a little bit. If you're not aware, I was not aware at the time. And it was at that moment, really, as we opened up, I said the president and I first talked about this in November. And of course, the inauguration, he had a lot more things to do and get set before we could begin working on this in March. But it hit me then that this was the perfect place to host this. And again, I thank the Museum of the Bible, and for those just tuning in, it's a great place to visit when you come to D.C. I'd say it's a can't miss. I want to introduce Anthony Schmidt. He's the Director of Collections and Curation. He has a PhD in American religion. He joined the museum almost 8 years ago, and I welcome you to tell us the story of the Bible.
Thank you very much. Thank you for having me, and welcome to Museum of the Bible. Yes, I've been here 8 years, and so that makes me a grizzled veteran at this organization. We opened in 2017, and so we're thriving here, and we're really happy to have you here today. And I'm thrilled to come and talk to you just a little bit, just for a few minutes, about one of the unique Bibles that we have in our collection, and that is known as the Aken Bible. It also has another name. It's the Bible of the Revolution, is what it's is often referred to. So the Aken Bible was published by Robert Aken in 1782, and there are a few superlatives that we can attach to this particular Bible. As I mentioned, it's known as the Bible of the Revolution, so 1782, it was published towards the end of the Revolution. And it was the first English language Bible published in North America. Now, I'll talk a little bit about that here in just a second. So the first English language Bible published in North America. Think about that, 1782 though. That seems kind of late, right? So 1782, and it's actually one of the rarest historical Bibles published in North America, in American history, essentially. So the first Bible that was published, the Eliot Indian Bible, there's actually more surviving copies of that we can count than the Aken Bible, which is pretty unique. But it also represents a watershed moment in the history of the United States, in the young republic. And so we'll walk through those in just a few minutes as I speak here today. So. Why did it take so long, 1782, to publish an English language Bible? Like I said, there had been previous Bibles published. The first Bible, 1663, the Eliot Indian Bible, 1663. That was published in Wampanoag, though. That was a dialect of the Algonquin language up in the American Northeast, the Boston area. The first European language Bible published in North America, that wasn't until 1743. 1743, and that was in German, by the way. A man by the name of Christoph Sauer in Germantown, Pennsylvania, outside of Philadelphia, published the first European language Bible. Okay, Robert Aken, 1782. What's going on? Well, if you wanted an English language Bible, you typically had to get it imported from Great Britain. Okay, so the Crown had essentially a monopoly, or they authorized certain printers to publish English language Bibles. And so you would have, London-based printer, Edinburgh, Cambridge, Oxford, some of the university printers, and all of those would be brought in to the colonies. Well, the Revolution put a cramp in that, right, along with a lot of other imports. And so all of a sudden, in the colonies, you had a shortage of English language Bibles that took place over the Revolution. So what do you do? What do you do? No one had ever printed an English language Bible over here prior to the Revolution that we know of. Now, you could get some pirated copies, some Geneva Bibles. You can get those in to the colonies. But if you wanted the King James Version, you would have to import that. Well, in 1777, the shortage was getting pretty noticeable, and a few ministers petitioned Congress at that time to think about publishing some Bibles because we needed to fill that gap. Well, Congress was short on funds. They were also at war, and they were about to be chased out of Philadelphia. This is 1777. So they did pass a motion to go ahead and import some Bibles from Holland, but it really didn't go anywhere. It didn't go anywhere. There were just too many other competing priorities, we can call it that. But there was a need, and there was a recognized need. So a Philadelphia printer, he was actually connected to Congress. His name was Robert Aken. Printed the Journal of the Proceedings of Congress and the Pennsylvania Magazine. So he was quite a prominent and established printer in the Philadelphia area. Born in Scotland, 1734. So he was kind of an older man by this time, well established, and he decided in 1781. After having printed a New Testament, just to kind of test the waters, he wanted to print a complete edition of the Bible. So the Old and New Testament. He left out the Apocrypha this time. So the Old and New Testament. And so he began work in 1781. And finally, 1782, they began to roll off the press. Now, what does he do? Well, he goes to Congress, and he's kind of in this mindset, well, for hundreds of years, the central government has been authorizing the publication of the Bible. He just assumed that we would have some sort of similar model here in the United States. We kind of can infer that's what he was thinking. But Congress didn't necessarily want a monopoly on Bibles, right? That wasn't in their realm of thinking there. And so I'm sure that there were some folks that would have preferred some sort of tight control over the publication of the Bible, but that's not the route they ended up going. So what Robert did secure from Congress was an endorsement. This was the only Bible that was officially endorsed by Congress. And so it received an endorsement, and it also he received permission to print that endorsement in his edition of the Bible. So Aken Bibles will have that congressional endorsement in the front. Was it a commercial success? Well, it came right at the end of the war, and what this would really signal, as I mentioned earlier, is a watershed moment in the history of Bible publishing in the United States. So it wasn't really a commercial success because the embargo would be lifted, and all of a sudden he'd be facing quite a lot of competition in the colonies from other printers. But what he did kind of trigger or start would be picked up by other printers. And all of a sudden in the colonies, because of this lack of religious establishment, because of this open market, you had all these printers who saw a void and began to try to fill that void with different types of Bibles. And so in quick succession, you have the first Catholic Bible, 1790, the Carey Bible. We have the first Family Bible, 1791, first Illustrated Bible, 1792, first Children's Bible, 1794, first Greek edition of the New Testament, 1800, by this guy named Isaiah Thomas, who was also connected to the founders. Not the basketball player, he was the printer. And so on and so forth. And you have these benchmarks being set by this founding generation that would be triggered and kind of kicked off by Robert Aken. And prior to Aken, you had no Bibles being published in English in the colonies. Literally within 30 years after Robert Aken, there are millions flooding the market in the United States, laying the establishment of the early republic, right? So this is going to be a Bible-saturated republic in a sense. And I could go on about the American Bible Society and all of their work that would come in 1812 and just the proliferation of the Bible throughout American culture then. So Robert Aken, the Aken Bible is quite a gem, and I'm happy to say, we have 3 in our collection. And including an Aken New Testament, which is quite rare, the New Testament that he printed prior to the Bible. And you can see those in person with your own eyes down on the second floor in our Bible in America exhibition. We have a case dedicated to the American Revolution. So that being said, I think I'm out of time already.
Any questions? And Carrie?
Is that better? Okay. This might be a silly question.
No silly questions.
What makes the Aken Bible so special?
What makes it so special? Its rarity. It's being the fact that it's the first English language Bible published in North America. The fact that it was connected to so many prominent people within our founding generation. It really is kind of a window into that time period that is unlike a lot of other objects, 99% of the objects out there in terms of just where religion fit within that time period.
Any other questions? I have one. Did that become the school book for most of our schools at that time?
What's interesting is Robert Aken intended for this to be used by school children. That was when he first petitioned Congress, he mentioned that specifically. He wanted to create a book that could be used in classrooms. And to my knowledge, the portion of the run that he ended up not being able to sell, he actually donated to schools in the Philadelphia region. So just to find some use for them.
Well, thank you for joining us and telling this story on the second floor and the story of the American Bible.
Yeah,
All
absolutely.
right. Thank you. Thank you very much.
Thank you so much.
Thank
It was an honor. Thank you.
Our first witness in this second portion of our first hearing, we have three witnesses this afternoon. Professor Stephanie Barclay is a professor of law at Georgetown Law School, where she also serves as faculty co-director of the Georgetown Center for the Constitution. Her scholarship focuses on the intersection of free speech and religious exercise. She's been cited numerous times, by the United States Supreme Court. Her background brings a timely and expert perspective to our proceedings. Dr. Barclay? And I'll also bring on, at the same time, Professor Joshua Blackman. Professor Blackman holds the Centennial Chair of Constitutional Law at South Texas College of Law in Houston. Professor Blackman is a nationally renowned leader on constitutional law in the Supreme Court. His extensive writing and analysis of emerging legal issues will provide insights critical to our understanding of where the law is now and where it may go in the future. And our third witness, Christian Wagoner, is the CEO, President, and General Counsel of Alliance Defending Freedom. She's one of the nation's most accomplished Supreme Court advocates, having successfully argued several landmark cases protecting free speech and religious freedom. Her extensive experience and ongoing leadership provide a practical and frontline perspective on the current threats to religious liberty, a topic to the directives of our commission that the President has asked us to hold these hearings on. Welcome, and Stephanie, you can begin.
Thank you, Mr. Chairman. It's an honor to get to speak before this distinguished commission today and to discuss the original meaning of the First Amendment's religion clauses, both the Free Exercise Clause and the Establishment Clause. In the spring of 1660, Mary Dyer climbed the steps of the gallows in Boston. Returning to Massachusetts Bay Colony in defiance of a Puritan order, determined to preach the tenets of her Quaker faith, the colony had ordered her to conform, to renounce her faith, and to remain silent. She refused, and for that, she was hanged. Mary Dyer may well be one of the first Americans who died for the cause of religious freedom. Before the United States existed, some of the American colonies and England itself were places where religious dissent could cost you your home, your freedom, or your life. And that grave reality remains true in far too many countries today. It was against this sobering legacy that the framers of our Constitution took deliberate action. They resolved to found a republic where conscience would be protected, not punished. In the very words of what became the First Amendment, they offered a bold and unprecedented promise. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. As this commission undertakes its vital work, I'd like to emphasize 3 foundational principles that should guide our understanding of this important constitutional provision. First, the Free Exercise Clause and the Establishment Clause were understood by the framers to work largely in tandem, not in tension with one another. After all, these 2 protections form part of the same cohesive sentence in the Constitution. Second, their unified aim was to prevent government from interfering with individual and institutional religious life as much as possible. Third, the Supreme Court's recent doctrine has largely returned to original meaning, moving away from decades of misinterpretation and ahistorical tests that artificially pitted these clauses against each other and provided far too crabbed of protections for religion in our society. The religion clauses represent one of America's greatest contributions to human liberty. They emerged from hard-won experience with religious persecution and a deep understanding that faith touches the most fundamental aspects of human existence. As James Madison observed, torrents of blood have been spilt in the old world by vain attempts of the secular arm to extinguish religious discord. As the principal architect of the First Amendment, Madison had witnessed religious persecution firsthand in Virginia, where Baptist preachers were jailed for preaching without a state license. Their imprisonment, following the dictates of their conscience, became for Madison a vivid demonstration of what must never be allowed in a free republic. So let me begin with the meaning of the Free Exercise Clause, which reads, Congress shall make no law prohibiting the free exercise of religion. The inclusion of the article the in the text, let me suggest, is not just a rhetorical ornament. It may signal that the framers were aware that they were not inventing a novel liberty, but recognizing and securing a long-standing one. George Washington expressed this understanding in his letter to the Quakers upon becoming elected president. He stated, quote, "The liberty enjoyed by the people of these states of worshiping Almighty God agreeable to their consciences is not only amongst the choicest of their blessings, but also of their rights," end quote. Washington said this, recognizing the existence of this natural and customary right to religious exercise before the First Amendment had even been drafted. The original understanding of this right was remarkably robust. It encompassed not just a right against religious discrimination, as important as that is, but also a right to live according to one's religious convictions, even when those convictions conflict with generally applicable laws. The case of the Quakers that you have heard earlier today provides a clear historical example of this. At the time of the founding, Quakers weren't willing to bear arms in the military service based on their religious convictions, and these laws were not discriminatory ones. But the government's ultimate response was not to force them to violate their conscience, but to recognize the futility and injustice of that sort of coercion. As Elias Boudinot, a prominent founding-era figure, explained, quote, "What justice can there be in compelling Quakers to bear arms when, according to their religious principles, they would rather die than use them," end quote. This reveals something crucial. Accommodating the religious exercise of sincere believers was understood to be necessary to reduce needless human suffering, and that principle remains true today. These early accommodations also reflect the founders' conviction that a healthy republic must cultivate principled citizens capable of dissenting on grounds of conscience. Of course, protection of religious exercise was not absolute. James Madison debated with George Mason about the limits of religious liberty, identifying a very limited category of government reasons for which government could regulate religious exercise. Madison rejected Mason's suggestion that we should be able to limit religious practices for the, quote, happiness of society. Madison said that's far too broad. Regulation would need to be justified on much more limited bases, like the need to preserve equal liberty of other citizens, or because the religious practice could endanger the very existence of the state itself. Early state constitutional protections for religious exercise also contained provisos enumerating the types of government justifications that were appropriate for limiting religious exercise when necessary. Things like government action necessary to protect the public health or public safety of the community. The early 1813 New York case of People versus Phillips, the earliest example of a religious exemption being granted, illustrates this principle in the judicial context. This case dealt with whether the government could subpoena a Catholic priest who had received a confession about a crime and force him to testify. Now, you can understand why, for the government, you would be very interested in this evidence, smoking gun evidence, if you can get it, about the defendant and the crime that they may have committed. And the government argued this was necessary for reduction of crime and for safety. But even though this law was not discriminatory, the Phillips court noted the burden the government's requirement would impose on the priest's ability to exercise his religion. Requiring him to testify would place him between Scylla and Charybdis, where the priest would be forced to either suffer penalties for failing to comply with the law or to violate his religious oath. In the face of this religious burden, the court demanded evidence that the government's actions would actually advance its stated interest in public safety and reduce crime, and the court found that evidence lacking. Mere assertions of risk or slippery slope arguments were insufficient, and the court ruled for the priest, granting a religious accommodation. An early case dealing with a nearly identical issue coming out of Virginia ruled the same way. The Free Exercise Clause, properly understood, was thus a guarantor of genuine religious pluralism. It was aimed at ensuring that America would be a nation where people of diverse faiths could live according to their religious convictions, even when those convictions set them apart from their neighbors or conflicted with generally applicable laws. This protection was seen as essential not only for the flourishing of religion, but for the preservation of a free society generally. Some have pointed to historical evidence that the Free Exercise Clause should be interpreted more narrowly. But virtually all of that evidence also supports arguments being debated at the founding about whether the judiciary should protect constitutional rights at all. For better or for worse, we now live in a society where there has largely been constitutional settlement on that issue, and where we understand that our judiciary is in the business of protecting constitutional rights. And so may I respectfully submit that in that context, there is no constitutional right with a stronger historical support entitling it to robust protection than religious exercise. I'll now turn to the original meaning of the Establishment Clause, an issue that some of the astute members of this commission were asking about this morning. This constitutional provision emerged in large part from the framers' experience with the Church of England, which served as a cautionary example of problematic church-state relations. The framers did not view all public roles for religion as problematic. Rather, they sought to prevent specific government actions that characterized formal religious establishments, while still allowing religion to maintain an important role in public life. Professor Michael McConnell has identified 6 historic hallmarks that characterize religious establishments that the framers were seeking to prevent. So beyond a formal declaration of an establishment, a prohibited establishment of religion could include one of the following. Number 1, control of church doctrine, leadership, or internal affairs. Number 2, compulsory religious exercise with penalties for noncompliance. Number 3, preferential financial support of just the established church and not other denominations. Number 4, prohibition of dissenting worship or punishment of dissenters. Number 5, use of church institutions for public functions in a monopoly capacity. And number 6, restriction of political offices to members of the established church. James Madison's Memorial and Remonstrance against Religious Assessments provides some crucial insights into the framers' views about these hallmarks of an established religion. Madison opposed Patrick Henry's proposed tax supporting Christian churches for 2 independent reasons, both relating to these hallmarks that I was just discussing. First, Madison objected to granting peculiar exemptions, as he called them, to certain religious groups, the Quakers and the Mennonites. He viewed this sort of preferential treatment of some denominations over others as problematic denominational favoritism. Second, Madison argued that the religious taxes required by this law effectively forced everyone to engage in a religious observance, or as Professor Mark Storsley has written about, effectively a tithe. Importantly, Madison's objections centered on the coerced religious participation rather than the government funding itself, which could be provided to religious entities for lots of other sorts of reasons. This explains why Madison and others who opposed church taxes in the form of tithes did not oppose state funding of religious schools. The latter did not involve coerced religious observance. Early American practice demonstrates that the Establishment Clause was not understood to require strict separation of religion from public life. The same Congress that drafted the First Amendment appointed official chaplains and provided for their payment. President Washington and Jefferson both acknowledged religion in their official capacities, and the federal government funded religious schools and religious displays in government spaces. Finally, on some issues, the religion clauses speak powerfully with a unified voice. The original understanding of these clauses encompasses institutional church autonomy, the right of religious organizations to govern their internal affairs according to their own religious principles, including selecting ministers and establishing doctrines without government interference. When James Madison was the Secretary of State, for instance, the Catholic Church solicited the executive's opinion on who should be appointed to run the church affairs in a new territory. Madison responded that selection of church functionaries was an entirely ecclesiastical matter, left to the church's own judgment, and something over which government should have no say. In conclusion, in recent years, the Supreme Court's decisions have increasingly returned to this original understanding. The court's 2022 decision that has been discussed earlier, Kennedy versus Bremerton School District, rejected the artificial tension between the religion clauses that had been caused by ahistorical doctrines like the Lemon Test. It adopted the 6 hallmark approach to the Establishment Clause, citing to Michael McConnell's work and a concurrence by Justice Gorsuch, highlighting in depth that approach. It also emphasized that the clauses work together towards the unified goal of protecting religious exercise and preventing unnecessary government intrusion. In Kennedy and other cases, the court has also interpreted narrowly cases like Employment Division versus Smith, which would not allow religious exemptions if a law is neutral and generally applicable. And now the Supreme Court has interpreted that case so narrowly that virtually no law at the Supreme Court, I would submit, could qualify as being neutral or generally applicable, which means that if a law burdens religious exercise and can't satisfy strict scrutiny, the court will grant a religious exemption. Lower courts are not so clear on this subject and are not as protective. And in Kennedy, in a footnote, the Supreme Court did leave open the possibility that they may yet overrule Employment Division versus Smith and make this reality crystal clear, offering more guidance for lower courts. The court has also recognized that government can accommodate religious exercise without impermissibly establishing religion. Religious expression in public settings is not presumptively unconstitutional. The court has finally recently emphasized just this term, that religious institutions have a robust right to autonomy in their internal affairs, and the Supreme Court did that in a unanimous decision. This return to original understanding creates space for genuine religious pluralism to flourish and serves the cause of religious liberty for all Americans, regardless of their particular faith traditions or none at all. But the important work of protecting religious liberty is never complete. Today, anti-Semitism is on the rise. Native American sacred sites are being threatened. There are many religious charities that face unnecessary obstacles to serving the most vulnerable amongst us. The Commission's work is vital to preserving and strengthening religious liberty for future generations. By understanding and applying the original meaning of the religion clauses, we can assure that America remains a nation where people of all faiths, and those of no faith, can live according to their deepest convictions while participating fully in our common civic life. I thank you to your attention to these important matters and for your service on the Commission.
Thank you, Professor Barclay. As we did this morning, we'll have another witness, and then we'll open for questions, and then we'll have our last witness and ask questions instead of having 3 together. Joshua, Blackman. I introduced him as the Centennial Chair of Constitutional Law at South Texas School of Law. Joshua?
Thank you so much. Chairman Patrick, Vice Chair Carson, it's an honor to be here today. And a point of privilege, I'm Jewish, Rabbi Soloveitchik is Jewish. There are many religions represented in this committee. I think that's a beautiful testament to the pluralism of our country. So thank you very much for making such a wonderful board. And also, if we keep our brothers and sisters in Israel in our prayers today, they're under attack at the moment. I have 10 minutes. You'll get 10 cases. So it's going to be very fast, but we will make this spin. The story begins in 1947, a case we've mentioned before, Everson versus Board of Education. This involves something benign, school buses. My kids take the school bus all the time. So in New Jersey, the school districts had buses that took kids to Catholic schools on public buses. An Establishment Clause challenge was brought, saying that this was unconstitutional. Now, the court upheld taking kids to the Catholic schools on the buses. But Justice Hugo Black, former U.S. Senator, said, aha, but we know the real meaning of the Constitution. It is not James Madison, as Stephanie said, it's Thomas Jefferson with this metaphor of a separation of church and state. And he said, this is what it means. No other evidence, nothing to say that's the real meaning. That's what it meant. And he says that this wall must be kept high and impregnable. It can't be breached. Not even the slightest breach be tolerated. So Black laid down the blueprints that the Establishment Clause means separation of church and state. We discussed this morning. That is not what the Constitution says. Not even close, my friends. So then about 15 years later, we get to a case mentioned earlier, the school prayer case, Engel against Vitale, 1962. My mom was actually a public school student in New York at the time. She actually remembers this. Schools began their day with the Pledge of Allegiance, which under Gobitis and Barnett, you cannot say. But after, there was a voluntary prayer, which, as I said before, was pretty, frankly, bland. Thank you, God, we're here. Thank you for the country, and so on. Nothing particularly egregious in any definition. Yet by a 6-1 vote, 6-1 wasn't even close. The court held that this was unconstitutional. Justice Black for the majority. Justice Potter Stewart wrote the lone dissent. And Justice Black says, we've breached this wall, this separation of church and state. There have been prayers in schools for generations. But suddenly in 1962, all of a sudden, this wall was resurrected. Poor choice of words, perhaps, in the Bible Museum. But the wall came back. And he said, this wall has been breached. Justice Stewart dissent. He said, this is not in the Constitution. You're making this up. Stop it. But that was the law. Justice Black wrote, when the Constitution was adopted, there was an awareness about the danger of the union, church, and state. And then Justice Stewart said, what are you talking about? Go a few blocks that way to the U.S. Supreme Court. Every day it begins, God save the United States and its honorable court. Every day. The House and Senate, a couple blocks that way. Every day there's a prayer from a chaplain. As Stephanie said, the very first Congress that passed the First Amendment paid for the chaplains in Congress. Every president, when they take the oath, say, so help me God. They ask for protection of God. George Washington on down. Pledge of Allegiance, one nation under God. In God we trust in every piece of currency, right? There is history here that the Supreme Court just looked away at. This was the Warren Court. They were making stuff about criminal procedure, about rights of privacy, penumbras, but God forbid the thing is actually in the Constitution. We're just going to push that aside. Then we get to 1971. This was a dark year for religious freedom. Roe came about 2 years later, so this is a dismal time for the court. The court decides a case called Lemon versus Kurtzman. Those are an appropriate name for a case. This was it. This case gave a so-called Lemon test. Again, it involved funding of religious schools. And the court puts forward this three-part test, which they just made up of whole cloth. This didn't come from anything. They said, here's the test to decide. They loved tests back then in the 70s. Here's the test to decide. So first, the law must have a purpose that is not religious. If there's a religious purpose, you can't do it. We discussed this morning, almost all of our laws have some basis in morality. This can't be the test. Number two, if a law advances religion, you can't have that. This isn't consistent with 2 centuries of precedent. And third, this is my favorite one, you can't have an excessive entanglement, whatever that means, an excessive entanglement with church and state. So even if, the government had to monitor a school to make sure they're spending the money properly, that's an entanglement, you can't have this. And what's fascinating is this was a test designed to protect religion. If you actually read the briefing, it said, we want to separate church and state to protect the religious because we want to protect people of faith from the government. If government gets into their hands, they'll corrupt the church. We don't want them. We are helping you. We're helping you. If you want the money, you can't have it. We're helping you. This was paternalism at its worst. Lemon created a 5-decade reign of terror for the religion clauses. Justice Scalia, Jerry Bradley, the great line, this ghoul that creeps in the night and comes to haunt our nightmares, right? This is how Justice Scalia described the Lemon test. So a couple of decisions that spawned from this. One, you have Stone against Graham. This was about whether you could post the 10 Commandments on the wall. Now, I'm in Texas, Governor Patrick's here. We passed a statute this year saying that the 10 Commandments we posted, we'll see what happens there. Another case called Wallace against Jaffrey, 1985, says you can't have a moment of silence in school. You don't have to pray, just a moment of silence. They said that will be too coercive. And then in 1992, a case called Lee versus Weissman. This was, again, not about Christian nationalism, whatever you might think. It was about a rabbi in Rhode Island who wanted to give the most ecumenical prayer ever, and a student, Deborah Weissman, objected, saying that I feel coerced to being seen. By the way, she was Jewish. So they brought a rabbi to give a speech, and a Jewish objected, but she felt coerced by even having this present in her graduation. And the court said, no, we can't have this. Adolescents are susceptible to peer pressure, right? And even being around, aware of a prayer is too much, and the risk of indirect coercion is unconstitutional. Okay, so those are the bad old days. We'll get now to the better times, the current times, the things that actually are in the upswing. So again, 2014, Town of Greece versus Galloway. This is not from ancient Greece, this is from upstate New York. The town council there began their sessions with a prayer, and they had a practice where they would go through the phone book. For children, there's a book that had phone numbers in it, right? They go through the phone book, and they would find all the numbers of parishioners in the area, and they would invite them to give an opening prayer. This case split 5-4. Justice Kennedy had the majority, and he said, this is okay. There's a long history of prayer going back to the time of the framing. No one's being forced to say the prayer. If you don't want to say it, you can just leave the room. And this is not a violation of the religion clauses. Justice Kagan dissented, and she objected, saying, you know what, I don't mind prayer. I just don't like these prayers. Why? Because they had the word Jesus, right? And they spoke of the Holy Spirit and things like this. We need just, she said, prayers are acceptable to everyone. This is the solemnity point made earlier, right? Just prayers that speak to no religion is the only religion we can have. That's not a prayer. I don't know what that is. It's just like like a pep talk. I don't know, right? What is that? So I think the court saw past that. But even Justice Kennedy said we can't have people coerced. I'm with you. I think it's a good test. Then we get to the trilogy. I think Professor said earlier, the trilogy of cases. So 2017, Trinity Lutheran versus Comer. 2020, Espinoza versus Montana Department of Revenue, and 2022, Carson against Macon. Boom, boom, boom. The court cited 3 cases over the course of 5 years that changed the law a lot. In the past, any funding of religion was basically unconstitutional. You just couldn't do it. So now the court's saying, wait a minute, if you're giving money to non-religious groups, you can't discriminate against religious groups. Those are good rules. But my goodness, we saw during COVID, casinos open, churches closed. So if we just apply this principle evenly, I think we're in a good place. Someone asked recommendations earlier. If we just treat religion the same as everything else, we'd be a lot better off. Don't treat a liquor store or marijuana dispensary better than a synagogue. That's a bad look. But we get to 2022 where things actually kind of right. My good friend Stephanie mentioned this earlier. Kennedy versus Bremerton School District. Kelly's group helped litigate this case for a number of years. This was a football coach. Coach Kennedy, you've probably seen him on TV, he gets around. They're good at that media stuff, right? He would give a prayer at the 50-yard line after the game. No one's required to say it to him. They sit down and pray, take a knee, whatever, and they can join if they want. The school said, we're afraid of getting sued, so you have to stop praying. That was actually the fear, right? They were afraid of the Lemon test. Because of the Lemon, they said you cannot pray. This case goes up and down. The courts finally gets to the court in 2022, and miraculously, Lemon was buried. Mazel tov, it's gone. No more. The court said the test now is based on history and tradition, and in particular, is there coercion? Not just, peer pressure, actual coercion, right? Are you forcing someone to pray? No. So this is the rule we have now. I think the court's still sort of figuring out where lemon goes. Does it go here? Does it go there? But that's a 50-year summary of the cases. I think if there's just one thought I can leave you with, it's this notion that merely being exposed to prayer, merely being exposed to a religious symbol like a Ten Commandments display or something like that, that is not enough to trigger the Establishment Clause, right? And if we start from there, almost all the other cases of the Ten Commandments displays and this and that, moment of silence, those cases go away. So the court overrule Engle versus Vitale? I don't know, right? That's on the chopping block. We have in Texas a bill that just got passed this past session. But I think it's a sort of bold moment. There's a lot of change ahead, and I think this commission meeting at just the right time to give guidance to the government of how to deal with this new reality. So thank you so much. Thank you to Stephanie, thank you to Kristen, the commission. I welcome your questions later.
Thank you. We will take questions now, and then we will have Kristen come up last, and then we'll have questions for you after. Kelly, you want us to lead?
Yeah. I know we just mentioned, some big cases that change things. The Carson case was a case we did, the Kennedy case. But I wonder from you what's next. I think you've already said a little bit, and I want to follow up a little bit on what Professor Bradley proposed. So kind of under both clauses. I think, Professor Barkley, from what you said, you're obviously not in favor of Smith, which lays out that.
Good guess.
Yeah, if the government lays out a neutral rule, there is no religious freedom violation. So it could literally go into Catholic churches and start arresting priests for, serving alcohol to minors. And so there's no religious liberty if it's neutral. Do you think but you said it's been so narrowed. So I'm wondering, do you think that is the biggest sort of case, the next case to overturn to restore free exercise because of all the lower courts and how they don't understand what's going on? Or do you think there's something else? And then the other question I'd ask both you and Josh is this issue that was brought up earlier of that Professor Bradley was saying government should be able to promote religion in general. And I know, Professor Barkley, you mentioned the religion clauses should be read together. And this idea that you can't promote religion as the government is really weird, saying that's a violation of the Establishment Clause when the Free Exercise Clause promotes religion in general. And so I'm wondering, do you think we should start moving in that way under the Establishment Clause, more things where it's okay for the government to be promotive of religion in general because it's a good?
Thank you for those excellent questions. So in terms of cases that I would like to see on the horizon, if there was a case that overruled Employment Division versus Smith and took the approach advocated by Justice Alito in his concurrence in Fulton that was joined by Justice Thomas and Justice Gorsuch and replaced Smith with a form of strict scrutiny. I think we've learned from RFRA, we've learned how to do strict scrutiny even more rigorously now. I think that would be a good thing for religious liberty because, as I alluded to in my remarks, even if virtually no law is described as neutral or generally applicable at the Supreme Court level, an awful lot are viewed as neutral and generally applicable by lower courts. And there's a lot of evidence about ways in which protection of religious groups, and particularly religious minorities, went down after Smith was decided, leading to a lot of the same types of needless suffering that I think our religion clauses were meant to prevent against. I think it would also be good to see the court, and you can see the court doing this in its recent Catholic charity cases, thinking more about how to develop the doctrine of church autonomy, that area that lies at the intersection of both religion clauses, and thinking more about the types of doctrinal protections beyond just the ministerial exception that will protect churches when it comes to the internal affairs of their church, how they're going to run different sort of staff or their programs. And I think that's an area where there's room for fruitful development. Under the Establishment Clause, I think more cases from the court making clear the different doctrines that it will adopt related to the different hallmarks of an establishment, I think would be helpful. My read, based on the court's jurisprudence so far, is that the court really ought to be out of the business of policing Christmas displays and Hanukkah. Ask, how many reindeer are there? Is that secular enough? That was never a question courts should be asking. They're not good interior designers. And my hope is that after Kennedy, they've given up that business. But future cases, I think, will help to really make that clear and to point out ways in which the court still is going to rigorously police anti-establishment clause concerns, but not in ways that, as you suggest, prohibit religion from being part of the public square or from prohibiting important church-state partnerships.
So I think I agree with everything Stephanie said on this. I would just speak more broadly. The Supreme Court in recent years has been trending in the right direction. I think they could push a little further, and Alice made this point earlier. Sometimes judges kind of hesitate. So I mean, even in Fulton, this is a case involving Catholic Services of Philadelphia. They've been doing adoptions there for like 200 years or more. And all of a sudden the city said, wait a minute, Catholic families, you won't put children with gay couples? Oh, you can't work with them. We're going to just shut you down. You should be more like Pope Francis Catholic. They said, be like Pope Francis and allow to place children with gay couples, which was insane. So the court unanimously said, okay, this goes too far. But you had 3 justices, Thomas, Alito, and Gorsuch, said, okay, Smith has had his time, let's go. 2 justices, Barrett and Kavanaugh, said, well, we asked some questions. I think they're answering those questions, still waiting to see what happens. But I don't know how far the court was wanting to go with this. Even this morning, we had a GVR, in legal speak. There's a case from New York State, right, where New York mandates that employers provide abortions, including apparently the Diocese of Albany. This case has been pending for a decade. And the court sent it back to lower courts again. The court didn't just grant the case, reverse outright. So I think as far as the court's gone, they're still sort of pumping the brakes, and maybe they're developing doctrine, maybe something else is going on. But I think these commissions are helpful to signal that there's support for these rulings. People, even non-lawyers, understand this doctrine, and that these rulings do frankly have consequences for people in the real world.
Questions? Dr. Anderson?
So I have a question for each of you based upon this term's Supreme Court rulings. Stephanie, I know you were litigating a case that just got denied cert. And there was a powerful dissent from denial of cert that I believe it was Gorsuch who wrote it. I was wondering, can you tell us a little bit about that case? And then since our job here is to give advice to the president, are there steps that the Trump administration could take specifically on that case? And then Josh, because Amy Coney Barrett had to recuse herself, the St. Isidore case was deadlocked 4-4. How should that case have been decided had there been a 5th? If you were the 5th deciding vote.
Oh, that's easy.
So tell us a little bit more than
Stephanie,
just the vote outcome.
Go ahead.
Sure. So thank you for the question. The case that Commissioner Anderson is asking about is a case called Apache Stronghold, where what is at issue is a Western Apache Native American sacred site in Arizona called Oak Flat, where they have performed sacred ceremonies since time immemorial. It's a portal to the divine for them. It's a space where the women in the Apache tribe perform their coming of age sunrise ceremony. So it's of critical importance to them, and it's an area that has long been protected by many different political administrations. The threat to Oak Flat has not come from this administration. It originated in a law passed during the Obama administration. And under that law, our government traded away this very valuable and very sacred site of the Apaches to a foreign Chinese-owned mining interest. What did we get in exchange for that? Some worthless land in the middle of the desert. So one thing I would say about that, religious liberty aside, I think President Trump should care about that because the man who knows the art of the deal should see that, this was not a good deal for our country, right? So that's number one. Also, the Native American people, there's one poll that shows that President Trump won 65% of their votes. This is a constituency that believed in this administration. And I think there's an opportunity for this administration to protect this sacred site where the courts and previous administrations have failed. So Justice Gorsuch, as Commissioner Anderson referenced, drafted an opinion joined in full by Justice Thomas, saying that he thought the Supreme Court should take this case and say that this sacred site was protected under RFRA and offer protection. There wasn't enough votes to do that, but there is an opportunity for this administration to do something. So under the statute, there is discretion provided to the Secretary of Agriculture to find mutually beneficial solutions in terms of the land exchange that would still be as limited of detriment as possible to the tribal people. And there are different sort of mining techniques that could be used that would not destroy the sacred surface of Oak Flat, but that could do mining underneath. It's also possible that President Trump could just decide he no longer wants to give away virtually for free really valuable United States land to Chinese mining interests, and he could indefinitely not issue the federal environmental impact statement because he could decide that this does not comply with our environmental laws or our valuation laws, requirements under the statutes, and he could take the position that the way that the mine is proposing to do this project is not the least restrictive means under RFRA, and so it doesn't comply with RFRA either. These are just a few discretionary options at the disposal of this administration. That's, again, a huge opportunity to protect a site that received broad bipartisan support of religious groups of all types in the amicus briefing, and to provide more religious liberty than predecessors or the courts have up until this point.
Thanks, Ryan. So the case you mentioned was called St. Isidore. This is very innovative. Oklahoma established a religious charter school that's online. People don't live in the city. It was managed by the Diocese of Cities in Oklahoma. The Oklahoma Attorney General, who sees himself as this religious conservative, he's not, said basically, I'm not going to defend this law. Sorry, Kristen's laughing. I'm not going to defend this law. I'm going to say it's unconstitutional. And the Oklahoma Supreme Court said it was unconstitutional. Okay. Goes to the Supreme Court, splits 4-4 with Justice Barrett recused. I'm not sure she would have voted. I'm not sure. I would have voted. I said it was a valid exercise of the state's power. After the trilogy of Carson versus Macon, Trinity Lutheran, and Montana, Espinoza versus Montana, you can't treat religion worse than non-religion. That's a very basic principle. If there are these non-religious charter schools, a religious charter school gets the same benefit. This was not a hard case. Now, I don't know that any state has another case in the pipeline. Maybe Texas should look at something like this. I think we have the charter schools now with the vouchers. But there's nothing else in the pipeline coming up. I think it's unfortunate for the children of Oklahoma. They lost this opportunity that they'll never get a chance to go to these schools.
Let me go to Dr. Carson, and I'll come to you, Rabbi. Dr. Carson?
Well, thank you for the illuminating discussion so far. A quick question for you regarding the Establishment Clause. I think most people would agree that it's not a good thing to kill people, or to steal, or to lie, or to covet, under those things. And yet, there seems to be a component of our society who feels like posting the Ten Commandments is establishing religion. Is it establishing religion, or is it talking about what is common decency for civilized people?
Yeah. I think there are two ways to look at it. So in the one sense, the basis of our legal system is the Ten Commandments. It's true. If you go to the Supreme Court, only a few blocks away, the Ten Commandments all over the place. They're everywhere, right? And no one gave thought. Moses was a giver of law. This is a very basic historical fact. But more fundamentally, there is a religious aspect, right? You shall have no other God before me, right? No graven idol. These are messages that have been taught for millennia in all civilizations that we can think of. The way I'd look at this, Dr. Carson, is I think we should try to think about the culture. If we tell students that anything you see that bothers you, we have to eliminate, not just religion, anything that bothers you, we have to eliminate, that is breeding children, I think, in a very harmful way. Versus if you see something you don't like, okay, you don't like it. Look the other way, have a different message. But the answer is not just to cancel or delete things you don't like. And if we apply that principle to the posting Ten Commandments, I think things will be a lot easier. But that's a cultural change that I don't think we can affect, but we can at least, I think, discuss in this commission.
I would just add to that and say I agree with you, Dr. Carson, that displaying the Ten Commandments doesn't violate the Establishment Clause for two different bases. I think schools should be able to teach about basic virtue ethics. All of the framers were well steeped in that thought. That was an important part of their own thinking. Although they fell short, as we all do, but it was something that they thought should be an important part of teaching, and long was. But even aside from just human decency, I think it's permissible for there to be religious displays that are obviously religious in public life, so long as it's not as though what is going on is that the government is saying, this is the one religious denomination that we support and not anything else. And the Ten Commandments falls far short of being anything like that.
Note before we get to Rabbi, on the Ten Commandments bill that we passed, Senate Bill 10, we do not fund those, and it's not an unfunded mandate to the schools. Any church, any individual, any business can donate a 16 by 20 copy of the Ten Commandments, which is the exact copy of the Ten Commandments we have on the Capitol grounds that the Supreme Court upheld. So that will be an interesting twist to this. But the schools are required, if you bring them the Ten Commandments, they must hang them in the classroom. Rabbi.
Well, thanks first to you both. I'm a huge admirer of your writings and your scholarship, and it's a joy to speak with you today. And on a personal note, just want to thank Professor Blackman for mentioning the war. Many, many close family members right now, along with many millions others, have spent much of the last couple of days in bunkers with ballistic missiles raining down on them. So thank you. It's appreciated very much. I wanted to ask about the subject of the course of the case law, which is what you both addressed so eloquently. It seems to me, and I'm not a lawyer, so correct me if I'm wrong, it seems to me that in the area of free exercise, there's been an enormous amount of rollback in a positive way, but much less so on the establishment front. Whereas there have been moments where, town of Greece is one, where the court said, okay, we're not going to go that far. But Plymouth Division versus Smith aside, and like Professor Barclay, I look forward to its being consigned to the ash heap of legal history. But that aside, so much has been accomplished. Blaine Amendment is effectively dead. So many important achievements for religious liberty have occurred, and yes, there are more, but there's been enormous achievements in recent times. And yet, it seems to me, whether we're speaking about placing of religious objects in public squares, 10 Commandments, prayer, so many aspects, even Lee Weissman, as far as I understand, is still the law of the land.
It is.
And so, why is that? Is this just a pragmatic matter that it hasn't that these cases have not come up as much? Is it because government has not acted with alacrity in pushing the envelope in this area, which is of course important to questions we face as a commission, because maybe then they should? Are justices more reluctant to grant cert to establishment cases, or do we have more cases to look forward to? I'm really interested in your thoughts on this question.
So I'll give an example as abortion, right? Roe v. Wade was law of the land 50 years. How was it overruled? Our friends in Mississippi passed a statute that was inconsistent with Roe. They passed a statute that was facially unconstitutional because they wanted to set up a test case. For better or worse, lower courts are bound by the Supreme Court. And if you bring a case, they'll say, well, Levy Weissman's our precedent, and until the Supreme Court says otherwise, that's our precedent. Right? And if the Supreme Court keeps denying cert, and they deny way too many cases, it won't be reversed. Unfortunately, the only answer is legislators who pass bills that perhaps are in tension with precedent. Stone v. Graham is one of them. The problem is qualified immunity, you're willing to pay damages and so on, but if you are willing to pass a statute that you think is inconsistent with the original meaning of the Constitution, you tell the lower court, Your Honor, we stipulate to judgment, we want to seek cert, right? I think that's going to happen more and more. Mississippi's done it, Louisiana's done it, Texas has done it. If you have a school district that's willing to have a good legal defense fund, they say, we will have a rabbi give a prayer at this thing, because we think Levy Weissman was wrongly decided. That's the answer. And until that happens, we're sort of stuck under the specter of these old Warren Court precedents that have haunted us for decades. Lemon's been extirpated, right? The court killed Lemon, but a lot of other cases are still floating in the ethos.
Let me just make a friendly amendment to that. I don't think that it's clear that Levy versus Weissman is the law of the land anymore. So the Supreme Court, when it talks about coercion in Kennedy, says that it needs to be compulsory religious exercise. And the hallmarks of a religious establishment that McConnell and Justice Gorsuch talk about that the court is citing to there refer to, and that type of coercion must be backed by penalties if there's noncompliance. There were no penalties in Lee versus Weissman. It was just, well, I feel kind of sad if I have to go to this graduation and somebody is praying. And that's not the same as the type of penalties that were relevant at the founding. So I don't think you have to go as far, respectfully, as Josh is saying, if you're a municipality and say, well, we're just going to buck the Supreme Court. I think you could say, we're reading Kennedy, and this seems to suggest that now, for it to be a historical hallmark of an establishment, it has to be more than peer pressure. It has to be real coercion backed by penalties to participate in this religious exercise. And so Lee is out, Graham is out with the Ten Commandments. And then will those cases be litigated? Probably. Do we need more clarifying doctrine so that we're not in the gray zone, but it's crystal clear that those things are not the law in the land? Sure. But I think that what the Supreme Court did in the Kennedy case, where it did make crystal clear that Lemon was dead, it was funny. They said, we've long ago overruled Lemon. So death for sure, data and death uncertain. But we know the ghoul is finally gone. And I think we have yet to fully appreciate the seismic shift that that case has opened up for us.
Thank you.
We'll go to Allison Ho, then Bishop Barron. Allison?
Thank you, Mr. Chairman. Professor Barkley, I want to go back and underscore something you said in your testimony that I thought was really, really important. And you were talking about employment division versus Smith, what some have called the Dred Scott of the First Amendment. And you said, well, even though the Supreme Court has, sort of made it little bit by little, like death by 1,000 cuts, right?
Right.
It's still doing damage and causing harm in the lower courts.
Right.
Could you talk a little bit more, and Professor Blackman, I'd love to hear from you too on this, on the human cost of sort of not being, when judges aren't clear and decisive in terms of, we're overruling this case, it's no longer the law of the land. Could you talk about the human cost in terms of that uncertainty and the gray area when we don't get that clarity? When courts sort of aren't willing to say, hey, this was wrong, we're going to correct the error and move forward.
Yes, that's a great question. Thank you. So let me address the human cost in two different ways. Think about Masterpiece Cake Shop, a case where the court decided that case on quite narrow grounds, and just sort of in a way that then kicks the can down the road. Well, that cake shop got sued again, right? Because the rule was not, if government is burdening your religious exercise, religious individual, then the government's going to have to demonstrate strict scrutiny. It was just, well, in this particular context, we could point to a double standard, and so we'll rule in your favor for now. But that's a much more limited protection, and it was a short-lived protection, right, for that baker. So that's true of the litigants in a case. And they're going to be, in the way that Professor Chris Lund has talked about, subject to the constitutional luck of whether we can point to things like secular exemptions in their jurisdiction or not. But more than that, as Professor Laycock has talked about, even though at the Supreme Court you're likely to win by arguing that a law is not neutral or generally applicable, it's a very complicated set of legal arguments that need to be made, ones that, yes, excellent institutions like those represented by Kristen and Beckett and others know how to make well, but that a lot of ordinary litigants or government officials don't. And a lot of government officials are more likely to just assume that a law is neutral or generally applicable when it's not. And Doug Laycock has written about the real toll of human suffering that has come about because of that confusion, because of time wasted fighting about those things. So there was a Jehovah's Witness woman in Kansas, I believe, who was requesting to be able to have a medical procedure that did not involve a blood transfusion, which violates her faith. And while they were litigating about whether the law was neutral or generally applicable and wouldn't rule for her below, even though it was cheaper than the other type of procedure, eventually when she won, it was too late. And Mary Simons died for her faith in the 21st century because we don't have a clear-cut rule that says, government, you've got to have a really good reason for burdening people's religious exercise. You've got to prove it with evidence. And when litigants can't walk in the door with that surety and they spend countless amount of hours and litigation resources fighting over neutrality and general applicability, that is the type of human cost we're talking about.
Thank you, Allison. Really good question. Time moves slowly for people who are seeking relief from the courts. Now, you mentioned the Roman Catholic Diocese of Albany for a moment. They've been fighting this abortion mandate for a decade. And the Supreme Court sent it back to the New York courts again for a second time. I think the court needs to grant more cases. And it's embarrassing of denials they have. Let's say DOJ, bring more religious liberty cases. The SG, file more amicus briefs in favor of certiorari. Tell the Supreme Court that people are suffering, as Allison said. People are seeking relief. And in clarity, Lemon was never overruled. Right? Gorsuch said, it was abandoned. It wasn't abandoned. Right? It was this weird prevaricate.
It is now.
It is now. But for the years between American Legion, there was a Ten Commandments case Alice mentioned earlier, where they just saw the arms off the cross, and Kennedy, Lemon was law. Lower courts applied it. So the court must speak clearly on these issues. Right? Maybe overrule Fulton, maybe we won't. Let's have some clarity on the issue. If you're not going to do it, get off the pot, as they say, right? Don't leave this some sort of academic exercise that might get resolved later when the votes simply aren't there. And if the votes aren't there, let us know that because we can focus on other things. Even with the major questions, not major questions, the most favored nation case during COVID, right? There are all these cases saying you can't treat religion worse, but then the court doesn't really cite those cases in Fulton. So I think there's just this maybe there's uncertainty in the court itself about where to go. But again, this is a presidential commission. This is not for the courts. Bring more cases from the DOJ's perspective. Have more amicus briefs. Has the DOJ said we think Smith should be overruled? Have they said that yet? Maybe they can, right? I think if the DOJ says Smith should be overruled, we've done RFRA, Stephanie said, for 3 decades. We know what it means to apply strict scrutiny. We know how this works. It's not like an unknown mystery of the world, right? Just the mysteries of the universe, right? We know this works, and it's not the end of the world. Half the states have RFRAs in effect, right? So there are ways that DOJ can do to sort of nudge forward.
I just want to co-sign that point about if the DOJ was willing to file more amicus briefs and look for good vehicles to overrule a case like Smith or to broaden Establishment Clause jurisprudence, I think that would be a helpful recommendation from this commission.
And Kristen, you haven't given your testimony. You will in a moment. We have a few more questions, but do you want to add anything? I should have introduced you into answering these questions as well.
There is so much I would like to add, but it wasn't my turn. I agree fully with these comments that are being made. I think when we look at, I'll talk in my remarks a little bit about Masterpiece Cake Shop, but 3 cases, 10 years, actually 13 years in. This is not uncommon. It's not rare. It is the normal thing that we endure and we see clients endure by not having their religious freedom rights vindicated. Even in the Drummond case, for example, why in the world would you resist including religious schools when, as our client had noticed when they approved the application, there's a 100% graduation rate from the entity that wanted to do this and a 98% college acceptance rate, and yet still Oklahoma officials, one in particular, the Attorney General, resisted this, which is blatant discrimination, and the court has called it odious under the Constitution in the past. The last thing that I will echo again is just, it's easy for us as lawyers to talk about what the Department of Justice can do, but who puts these officials in place? And what is the role of the non-lawyers? Because these fights don't just sit in the courtrooms and in the legislatures of the United States. They sit at our dinner tables with our children. They sit in the workplaces that we go into and in the ways that we volunteer in engaging in a civil society that values freedom. So I would just encourage that as well. That's my 2 cents. Thank you for the opportunity.
Well, you'll get a few more cents here in a moment. Bishop Barron?
Yeah, thanks very much for both presentations. I especially enjoyed that review of the cases as a non-lawyer, just to see it laid out that way and how we've evolved. I can't tell you how many people, knowing that I'm on this commission, have said to me, from my Catholic colleagues, bring up this problem of the Washington state law about compelling priests to, violate seal of confession. Yeah. We fought in California. I was an auxiliary bishop out there for 6 years. This came up in the legislature. We fought it. We stirred our people to resistance. They flooded Sacramento with complaints, and it never got out of committee. So, we breathed a sigh of relief. Now it comes up again. To my, non-legal mind, it's the most outrageous violation of the free exercise clause that I can think of, or the state involving itself illegitimately in the interior working of a church. And I don't think anything will lead Catholics to more open opposition than if that stuff, starts spreading across the country. Please tell me, assure me, that this is not going to survive a judicial review. I can't imagine. I'm curious to know, to me it seems so outrageous and so clear a violation, but help me understand that better.
I agree, but I want to punt this to Kristen.
Go ahead.
So Kristen, go for it.
You have some real expertise.
It is a violation, and there are a couple of cases I know that have already been filed, including one that we filed. But I do also, it is a violation of free exercise, but this is common particularly in blue states where we see aggressive states like Washington try to limit religious freedom. And when we don't take those stands, when the Catholic Church doesn't stand up, when the evangelical church doesn't stand up in those moments because they're afraid of being labeled, for example, as being pro-child molester, what happens is bad law is created, and then that law transcends to all the other states that are willing to pass it. And the last thing I just would say on that, and punt the more legal analysis to Stephanie, is that the very first case that I litigated was a case involving the priest penitent statute in Washington State. I came from Washington State, practiced there for nearly 20 years. They have been going after the privilege for that long, and we see this again and again and again, which underscores the importance of us as people who believe in religion helping the public and legislators understand the sacredness of that, why that privilege exists, and the goodness behind it. And that's something that I think this committee can really focus on, as well as an educational component of the value of religious freedom.
Yeah, some cases, it might be a little tricky to know whether what the government's doing is neutral and generally applicable. That is not one of them, right? And this actually reminds me of the case that I was talking about in my opening remarks of People versus Phillips, again, where we're trying to single out Catholic priests in that case. And there, the arguments that apply there, I think you would also make here. The government was saying, well, we need to take away the ability to reserve this sort of confidential testimony because of the need to reduce crime. And the court said, well, you have exceptions for a lot of other things, and yet you're still able to reduce crime. Why focus in on just this one? And I think that same question applies in this case, and I think the government will be hard-pressed to have a good answer to that question.
Bishop, Kelly Shackelford's firm is actually handling this case. I asked him to weigh in for a moment.
Yeah, it's a pretty basic religious freedom, and Beckett and First Liberty, we're both on that case together. And that's sort of, I don't know, a theme that I wanted to bring out, and you're kind of bringing it out a little bit, is the New York Times has written recently, well, they're winning on religious liberty. They've won 12 of the last 15 cases. But that's 15 cases, not thousands and thousands of cases that die below, that they don't take, that never get up, that people's lives are destroyed in the process. And so, you know, it's really important that the commission has a lot more work than just these Supreme Court cases that, you know, over the last 15 years might make up, 12 wins at the Supreme Court. There's the ones people don't hear about. And as Allison Ho was bringing up, a lot of people know about Jack. I mean, he's a great client. A lot of people, some people do. We have a very similar client, the Kleins, and they had their shop destroyed essentially because of what happened in Oregon. They were fined $135,000 because they wouldn't do a same-sex wedding cake because it violated their faith, although they provided all kinds of accommodations for these people. It is now 13 years that they have been in litigation. They have been up to the Supreme Court twice, had the court vacate the decision from the Oregon courts and send it back down. And, how long are we going to put these people through this? They've had to move states. They're now in Montana instead of Oregon. This is not religious freedom. Even if they win, this is not religious freedom. And so, I think an undercurrent theme to this is the courts need to do a better job. They don't need to try to avoid having to make decisions. Their job is to make decisions and protect the Constitution.
Were you finished, Bishop? Paula, Pastor?
Thank you. This dialogue and discussion is so vital and excellent. And I agree, Kelly, the process is often the punishment. And Kelly asked my question on the Lemon test, so I want to go back to you, Kristen. You talked about who puts these officials in place, and you said how it's so important for the Catholic Church and the evangelicals to be involved and to stand up. So number one, let's talk about how important is that, and what's the pathway for them to do that? Because I know many faith leaders, and you have thousands of thousands. Number one, there's a fear because of intimidation by government, so we've got to eliminate that fear. But also, there's also an ignorance. My people perish because of lack of knowledge. They sit in darkness. Let's bring that to light. What is the best pathway to be effective with those who are fighting these fights?
Well, as I've been thinking about today, one of the things that I hope that this commission recommends to the president is that he use the platform that he has in the administration's platform, as he has already begun to do through your office and other ways, to help Americans understand what the threat is and the goodness of practicing one's faith from whatever perspective one's coming from in that, and also to educate Americans on what their rights are. I think that has been critical. For so long, we would see laws that were being passed that were blatant violations of constitutional rights, and yet people would forego exercising their rights rather than have to stick their neck out and potentially subject themselves to government fines or even jail time, which is what some leading victims happened to receive. And that, for example, in 2012 is when we saw Jack Phillips was one, but there were 4 or 5 in that 2012 period that literally were defendants, and that scared people. Now we see this vibe shift, but I would submit it's a temporary one. It's a change of power, not a change of heart. And we need a change of heart. And this commission can do a lot to help educate Americans on why religion is good, and the religious community themselves can actually model courage and charity. And there are many ways that we can do that, but I think that would be one of the most significant contributions that this commission could make. I had a commissioner from the EEOC during President Trump's first term talk to me about the fact that there were a number of minority religions that very much knew what their rights were and repeatedly filed complaints, for example, when their rights were violated, and that allowed the federal government to address those things. But yet we see traditionally, frankly, in evangelical communities and Catholic communities, there is not that same level of willingness at this point to step out, because they don't want to offend and certainly don't want to get in the crosshairs of hostile government officials.
I want to move on to, there are no more questions, move on to, Kristen, your testimony, and Joshua and Stephanie, if you'll stay there. And we may have some closing questions in addition to what Kristen is going to testify on. So Kristen Wagoner, again, the CEO, President of General Counsel of Alliance for Defending Freedom, one of the most accomplished Supreme Court advocates, having successfully argued several landmark cases protecting free speech and religious freedom. All yours.
Well, good afternoon. I haven't said that yet, but good afternoon, Chairman Patrick and Vice Chair Carson, and to the members of this committee. It is truly an honor to be here with you, and thank you for your continued service to this nation. It's a vital effort. It's a privilege to be here today, and it's also a privilege to be able to serve as a member on the advisory board to the commission as we do this important work to protect religious liberty. I also want to express my gratitude to President Trump for making this a priority in this moment, and to, again, making it a priority to trust you and to trust us in this moment to protect freedom. But I want to begin in a place maybe where most speakers haven't yet, which is not with our founding fathers, but actually in 1974. Soviet authorities had arrested Alexander Solzhenitsyn, and in doing so, they were getting ready to send him into exile. He was a world-famous dissident. He had become an unbearable threat to the Soviet regime. And the reason that he had become that threat was because he had spent 8 years in the Soviet Gulag. During that time, he had seen cruelty and oppression from communism firsthand, and he had dedicated the rest of his life to exposing it, to exposing the truth at great risk to himself. But what I find most interesting about Alexander Solzhenitsyn is that actually he referenced the fact that the deepest rot in Soviet society wasn't just found in the government itself. He actually said that it was a people who tolerated the government and a people who failed to confront it. And in fact, it was this critique that went all the way down to the ordinary Russian man on the street, who kept his mouth shut and his head down, and sometimes even repeated the lies of the Soviet regime simply to avoid suffering repercussions. It was that lack of courage, the spiritual malaise that we saw, that Solzhenitsyn referred to as an unconscionable gift to the Soviet regime and the deepest form of human slavery. And in fact, on the eve of Alexander Solzhenitsyn's exile, he gave a parting gift to the Russian people in the form of a letter. And I want to read those words to you. He said this: "We have so hopelessly ceded our humanity that for the modest handouts of today, we are ready to surrender all principles, our soul, all the labors of our ancestors, all the prospects of our descendants, anything to avoid disrupting our meager existence." It seems appropriate, given all that we've heard today, to reference that. I know that much has changed since 1974, but I do believe that those prophetic words do ring true today when we speak of religious freedom. America's legacy of strength and its foundation for enduring greatness rests on how we protect the freedom to speak, to live, and to work consistent with our deepest beliefs. Beliefs that point to a more noble and higher purpose and authority than what we ourselves can offer. Our founding fathers understood this, and that's why our Constitution references and guards these God-given rights and requires our government to do the same. But I also want to remind you today that many other nations have protections like the ones we find in our First Amendment. But their courts and their people have stripped these promises of any meaning. Our international team at ADF sees this on a daily basis. In fact, we have cases on 5 different continents right now. And in the last year alone, we have represented nearly a dozen individuals in the UK alone for their willingness to speak their faith, including Adam Smith Connor, who just recently was convicted in the UK for silently praying outside of an abortion clinic where his son was aborted. As we have referenced today, there is a human cost when government officials forget freedom and judges forget courage. But thankfully, as our 2 distinguished panelists have already shared, the U.S. Supreme Court has worked to ensure that elected officials don't violate the Constitution, and they've generally upheld religious freedom. But it has been incremental at best, and we must do more. So, I would encourage us, before I move on from the international topic, to let this sink in. The United States right now is the last Western country in the world to provide robust religious freedom and free speech protections. Ponder that for a minute. The last Western country in the world. I've had the privilege of litigating more than a dozen Supreme Court cases that uphold our fundamental freedoms, and I have seen the client's relief when justice is done after years of government harassment. But the fact that more and more justice requires a courtroom is a deep, deep warning to us. We are teetering on the edge of losing the freedoms that make America the freest, most exceptional nation in history. If we fall silent now, we will fail the next generation. But we will do more than that. We will fail the soul of liberty itself. Because this is precisely how authoritarian regimes begin. They silence the soul. There is no greater threat to tyranny than the freedom to speak the truth. And yes, I know that today's tyrants, they don't wear crowns. They aren't kings, as we've heard. But they do often sit on our school boards, in our civil rights commissions, and on our city councils. And they're openly hostile to freedom and unmoored from objective truth. They censor, they fine, they even threaten jail time to Americans who dare to hold different beliefs than they do, especially if those beliefs have anything to do with the dignity of life, God's design for marriage, or the simple truth of what it means to be a woman. Truth is the first casualty of tyranny, but the real cost, it is always human. Imagine being so inspired by your faith that you dare to open a homeless shelter and give your life to it, only to have the state tell you that you either abandon that faith or cease serving those in need. Or fostering children for years at a time, and you're the health department's first choice to place newborns that are addicted to drugs, until you say boys are not girls, and the department then revokes your license. Or what if you escaped 20 years of sex trafficking and faced an unexpected pregnancy, only to be later targeted by your own state attorney general for helping other women in similar situations? Or you're ministering to widows and orphans, only to have your bank account shut down and to be denied access to capital because of your faith. Or during COVID, your daughter chooses to wear a Jesus Love Me mask to school, but school officials force her to remove it, even though it allows students wearing other messages in school. Or perhaps you served your country in uniform, risking your life to defend freedom, only to have officials deny you a public grant that is available to all other students, but not to you, because your desire to become a military chaplain and pursue that degree is simply too religious. Or your home state calls your faith a despicable piece of rhetoric and then compares your timeless beliefs about marriage to perpetrators of the Holocaust These stories are not from nations that are ruled by authoritarian regimes. Each of these, every single one of them, has happened in real time on our own soil. And we have been honored to represent these courageous Americans who are standing for freedom, but that stand does not come without a cost. One of the greatest privileges I have had in my life is to argue the Masterpiece Cake Shop case at the Supreme Court. But the bigger privilege was to walk beside Jack Phillips through that 13-year crucible. He was a model of charity and of faithfulness. Thankfully, the court ruled 7-2 that the Colorado Civil Rights Commission showed impermissible hostility toward Jack's religious belief, and that the Constitution commits Americans and government officials to religious tolerance. For it is in protecting unpopular religious beliefs that we prove this country's commitment to serving as a refuge for religious freedom. But as has been referenced, even a Supreme Court ruling wasn't enough. We had to go back up to the Supreme Court in a different decision, 303 Creative, and then back up to the Colorado Supreme Court. And at the end of the day, the financial, the emotional, the physical toll that took on that family was incalculable and impossible to fully remedy. You see, no nation can survive, nor can its people flourish if its officials believe that they can regulate the soul and excise beliefs that are held sacred by all of the Abrahamic faiths. So we must ensure that the United States remains that refuge for religious freedom. And it's why we gather today, because political and cultural winds should not shift. This is not a Republican or a Democrat issue. It is a moral and cultural imperative. As President Trump has said, in America, we don't worship government, we worship God. And we need leaders at every level of our government with the courage to resist the tyranny and respect the bedrock of American life, every citizen's absolute right to peacefully live according to the teachings of their faith and the convictions of their heart. So let me bring this home. How can the administration do that? I would submit a few recommendations to you. First, restore the Conscience and Religious Freedom Division at HHS and establish similar divisions within other departments' civil rights offices, and ensure equal access to federal funding is consistent with recent Supreme Court precedent that's been mentioned today, and enforce all federal conscience laws, holding accountable recipients that violate those laws. Support the Conscience Protection Act and support the Families' Rights and Responsibilities Act. We've heard today about the importance of parental rights in protecting religious freedom. There is an act that is pending and introduced right now that can do that. Second, we must end the financial targeting of people of faith. Ensure the IRS doesn't discriminate against houses of worship or religious organizations, and protect these entities from unjust penalties under the Johnson Amendment. Guarantee that prior weaponization of financial regulations and markets against people of faith never, ever happens again. Support the Safeguarding Charity Act, which protects the independence and tax-exempt status of charitable organizations. Third, protect people of faith from the regulatory state. Develop rules that prevent future administrations from labeling as domestic terrorists Americans who simply purchased a religious text or spoke at a school board meeting. And require religious training for FBI agents. Fourth, promote religious freedom on the international stage. In collaboration with the Ambassador at Large for International Religious Freedom, implement President Trump's 2020 executive order on advancing international religious freedom to ensure that religious freedom remains a central priority of U.S. foreign policy. Finally, a president's most lasting legacy, as we have heard so much indirectly about today, is the men and women that he appoints to the judiciary. President Trump must continue to do more than appoint originalists to the bench, but to appoint judges with an established record of courage, character, and conviction, who will apply the law without fear of public opinion. Our rights under the Constitution become meaningless without an independent and a virtuous judiciary. So in closing, Religious freedom built America. We've talked about that today, and it has sustained it through war, through depression, through dangerous division. And faith-filled leaders founded this nation. They've abolished slavery. They ended segregation. And even today, they continue to champion women and families and the most vulnerable. And it is that same faith, expressed freely and lived boldly, that will lead America to renewed greatness. Why? Well, because we can stand confidently that religious liberty is the essential way to pursue the truth. It's rooted in a love of neighbor and empowers every person, regardless of faith or party, to pursue truth without coercion. And along with free speech, we must recognize that it is the engine of self-governance and a bulwark against tyranny. It also fuels human flourishing, breathing oxygen into a free society, because where it is honored, we also need to recognize that families are strengthened, churches and communities can better cultivate virtue in the citizens. That's not the government's job. And economies thrive, and individuals are able to freely share ideas and robustly debate those ideas and to live for a purpose that is greater than themselves. Religious liberty is the American rebellion against every regime that has ever tried to own the human soul. Undermine it, and we don't just violate the Constitution. We deny humanity its most sacred right, and we frankly will jeopardize all of Western civilization. So I am thankful to you. I am encouraged that you are poised to meet this moment and to safeguard America's legacy of strength and greatness for generations to come. Thank you.
Thank you, Kristen. Questions? Christian? Dr. Anderson?
Kristen, could I was struck by a lot of what you said, but I want to draw you out more on 2 points. It strikes me that there are at least 2 different types of religious liberty cases. Like sometimes the underlying law is justified, but we're applying it in a way that unjustly burdens minorities. So think of like traffic laws. You need to have headlights and electronic taillights, but the Amish don't use electricity. And we say, all right, well, we're not going to impose this on you. You can put that triangular reflective thing on the back of your horse and buggy, and it's a win-win, right? We can accommodate the Amish, and we can protect vehicular safety. But then it strikes me that there are other religious liberty violations where the problem is actually the underlying law. It's just unjust. The Montgomery County pornographic children's book, right? That's not a religious liberty problem in the first place. The underlying problem is that they're assigning pornographic books to kids, right? Mm-hmm. You've had clients where religious schools were being told they would have to house boys that identify as girls in the girls' dorms. Or I think of your Anchorage client, a battered women's shelter that was told you have to have an intoxicated male sleep in the same shelter, right? Because he identifies as a woman, right? So I guess my question there is, how should we think about this other category of case where we're not just asking for an exemption, but at the end of the day, like the unjust law is the problem, and it's a problem for everyone. And then the other thing that came out in your comments is that it's not just government that is threatening religious liberty. We're also seeing this a lot in the private sector. And you had mentioned some of this with some of the technology, some of the debanking. Mm-hmm. Now, I think some of these cases, government has put private actors up to it. So I know I have a colleague who was censored by Twitter during COVID. He was a medical doctor that was, questioning the science, and you weren't allowed to question the science. And so Dr. Fauci and others from the Biden administration, he was on the list of doctors and scientists that they were supposed to censor. I've had my own experience with Amazon, et cetera, et cetera. How should we think about the threats to religious liberty that are coming from the private sector, especially big tech, and especially when there is that intersection of government, asking the private sector to do things that it would be illegal for the government itself to do?
Well, I think you're right to point out we do need religious exemptions, but we also need to have our officials and the public understand that we should be passing unjust laws in the first place, because unjust laws create real victims. And I think we're seeing that more and more play out, particularly as we look at gender ideology and the threat that gender ideology has posed to religious freedom. Not just posed, but really the way that it has undermined First Amendment rights in many respects throughout the nation. From our viewpoint, it is based on a false anthropology, and that false anthropology, meaning that it is a lie, means that the only way to tolerate that lie is through censorship itself. So religious freedom and free speech are very much hand in glove. You cannot have one without the other. I would also say that on that front of gender ideology and these unjust laws that represent a flawed view of the human person, of common sense and biology, we know that you can ignore that truth, but you will never be able to ignore the consequences. And those consequences we see every day. Certainly, we could go through the emotional and physical toll that it has taken on individuals and families who have been fooled by a medical establishment in what has been the most disastrous medical experiment in a lifetime. But I also would say that when we look at censorship and the way that that is played out, it has crushed the rights of religious freedom and free speech in local and state levels in ways that has even surprised us. I think I'll mention a couple of policy ideas in that. Again, HHS, the Department of Education, and others, our Center for Policy has dove first place into this to be able to, at the local, state, and federal levels, ensure that laws don't get put in place that are bad and, in fact, have laws that represent the wholeness of the human person. Also, we need more robust religious freedom protections in those laws, because now it's no longer a question of bipartisan believing that there should be exemptions. There literally are efforts to take away religious exemptions that are in place in the law right now. I also want to mention on the parental rights front, because this ideology is eviscerating parental rights as well as the right of religious autonomy if it gains traction. And we are seeing a number of cases involving secret transitions of children where this is the formal policy in public schools right now. And it's not in places like, New York and Washington State. I mean, it's there too. But it's in Kansas and Wisconsin and Arizona and all over at the local level. So we have to stand for parental rights, and I would encourage you in any recommendations you make to make sure you address that. The last thing that I will say on this unjust laws concept is that there's a case right now at the Supreme Court, the Childs case, which, the federal government can not only address in terms of how the Department of Justice addresses it, but use the bully pulpit and a voice of leadership to talk about the fact that children who are experiencing gender dysphoria should be able to get help for that and not be sent down a one-way treadmill that essentially makes them lifelong patients. And a number of states have actually right now outlawed, literally told counselors they will lose their licenses if they try to help children live at peace with their bodies. So those are some ideas on that. Briefly, I'll just touch on the censorship issue, because it also has led us to the Center for Corporate Engagement is a new area we've gone into, because as we want to be fighting these issues in legislatures and in litigation where the fight belongs, we're seeing the fight move into the corporate boardroom. And that means that the First Amendment doesn't generally apply unless there's collusion there. So moving these companies back to a place where they feel the public's pressure, where shareholders are engaged in this process, is extremely important, to the point of we have researched 92% of the large online platforms right now have hate speech policies or vague standards that they're using to discriminate against conservative and religious folks. And they're relying on the Southern Poverty Law Center's list. And that list is horrendous in terms of who it affects. It's not just Alliance Defending Freedom, but it's Family Research Council. This last 2 weeks, it's been Focus on the Family that is now. Moms for Liberty, Turning Point USA, Do No Harm. So this commission can do a lot to recommend to the president to take whatever steps necessary to rid the government at all levels, and urge states to do the same, of these concepts, because they're doing nothing but forcing people from the market of ideas and actually the financial markets, because they have traditional religious beliefs.
Thank you so much for your presentation. It was very, very moving. You spoke about the intersection between law and society, and so I want to ask a little bit about that. The rights that we seek to defend impact and are important for every religious community, every community of faith in America. And the threat to the liberty of one community threatens everyone. And at times, it seems we understand this, either because of contiguity and geography, or for some other reason. So, thus, during the pandemic, when Supreme Court granted relief to religious communities when it came to houses of worship being closed and liquor stores being open, I think a relief which was issued by the Supreme Court on Thanksgiving, I think, appropriately. The two cases were Catholic Diocese of Brooklyn versus Cuomo and Agudath Israel of America versus Cuomo. So that the very names of the cases should teach us something. And so because you're seeing religious liberty cases around the country, the question then is, on a social level, obviously when if you see a certain case, you're thinking about what that can mean as a future precedent for everyone. But if you see a small community impacted, a church impacted here, a synagogue impacted there, a store owner impacted, is there anything in place now that A, can allow that person, that litigant, that community to feel they are not alone, and to allow other communities around America to really understand that this impacts all of us, and we need to stand with these people that are heroic, standing up for the rights of us all. So that's a question. I was wondering if you had any thoughts about that.
Well, I think it's something that we need to do more to ensure. The most common comment that I get from clients, including churches and synagogues, and they say that they feel alone. And when you, as an example, stand up for your faith or your religious convictions, it can create hostility from civil servants in your community. It can also mean that you receive death threats, aside from just the normal cancel culture. So I do think it's important that the American public stand up. We've done some things at ADF to help draft letters, help bring religious communities and pastors around those others when we have cases. But I think that there could be something more formal. I think back to, days when I think it was around the time of the Manhattan Declaration and when that was created, and how Chuck Colson and other leaders of all different faiths came together to stand together for certain things. And there really was an effort to be ecumenical in that stand. But I truly believe that we stand or fall together, and we need to recognize that. The same precedent applies to every denomination and every faith.
Right. Thank you. Professor Barkley, please.
Can I just add something?
Yeah,
very brief to
please.
that? So in that case, the Agudath Israel case, during that time I was at Notre Dame, a professor, and I also directed the Religious Liberty Clinic, and we filed an amicus brief representing Muslim scholars and organizations who spoke out in defense of the Jewish community. And they said, we remember what it felt like during 9/11 to be scapegoated and treated unjustly, and that is happening to the Jewish community now. And it wasn't okay then, it's not okay now. We want to stand with our Jewish brothers and sisters and just acknowledge the injustice of what's going on right now. And this had to be filed quickly. It was an emergency briefing, but it meant a lot to the clients in Agudath Israel. They asked us to file that again as it went up in the Supreme Court, just to have other communities, this Catholic institution, Muslim groups, who this was not their fight, but they were saying, we stand in solidarity with you. And to me, that's the best of our American religious tradition.
Thank you. Just to speak in agreement, I remember when I testified about the threat to religious liberty to Christian universities during the health law, the mandate case in 2012. And I was asked about why I was testifying, and I said, well, what impacts Notre Dame today essentially could impact Yeshiva University in the future. Sure enough, but we rise and fall together, as you are all saying.
Yeah.
Thank you.
I'll
Professor
just-
Blackman, you have something on this, please.
Yeah, I'll say as a brief point. So during the COVID scare, I work with the Beckett Fund. I'm with a group called the Jewish Coalition for Religious Liberty, and we represented a Jewish school in New York. Remember, there were these zones. If you were on this side of the street, it was a red zone, there was a yellow zone, and magically, all the Jewish schools were within the red zone. Just amazing how they drew these lines. And it's just amazing how that works. And we actually sued them on Erev Sukkot, so it's on a Friday afternoon. We filed a lawsuit. And I think by Monday, Governor Cuomo just changed the line to put our school outside the red zone. And so maybe a topic of future discussion is the COVID cases, where a lot of these governments knew they were getting in trouble, and they kept changing the policy over and over again so they could never get caught in court. And these cases, oh, moot, oh, there's all this moot, we can't do anything. But we could do stuff, right? This body can investigate, and it could be a worthwhile discussion of how to sort of look back at the awful COVID days and realize how never, ever, ever do that again.
Absolutely. Of course, just to emphasize again, I'm not suggesting this is all about self-interest. It's not, none of us are. A violation of anyone's faith is an injustice in and of itself. But we do need to, I think, do a better job of ensuring that heroic litigants are not alone, and that we all realize that we are in the same boat.
Carrie?
Thank you. I want to say thank you so much as a mother of small children. You have more courage than most men in our country, and I want to applaud you for that. One thing that you touched on that I think is really important is courage. And I think so many people fear man more than they fear God, and we really need to stop doing that. We need to stop fearing public opinion versus fearing one day being told, "Depart from me, I never knew you." I would like you to touch on the Johnson Amendment briefly. I think that's very important. I think that so many pastors, with talking about courage and the unwillingness to speak out publicly, whether it's, to endorse a candidate. Kelly, you've touched on this before, the rights of pastors and priests, the rights that they have to endorse candidates and stuff like that. But I want you to touch on the Johnson Amendment and kind of what that did to the church and what that did to Christians and Catholics, really silencing them and basically telling them that they don't have a place in the political sphere. Because I think that was really damaging, and I think that's caused many people to live in fear of consequences, financial consequences, and things like that. So just
Carrie,
touch on that.
we are going to have, and the list is not out, but we're going to have a full hearing on that.
Oh, very
So that will
exciting.
be a half of a hearing. But if you'd like to answer, kind of a short answer, it'd be fine.
Sure. I would just say that I think that the Johnson Amendment laid a foundation for churches and religious leaders to decline to engage in the political system. And it's very unfortunate. It's also unconstitutional in our view and deserves to be challenged. I think that the IRS over the years has played a game in not allowing it to be challenged and how they've navigated that. But the other part I want to go back to is what you began with, which is courage. Because more and more we're seeing legislation that is impacting the heart of the religious tenets, not just of one faith, but of all faiths, things that we have held dear, how we hold our families, how we raise our families, what we believe about God even, and the way to salvation. And as the government has spread into these other areas that it has no business being in, religious leaders have hidden behind the Johnson Amendment to decline to speak and to make the words of God, the words be true in their lives and make them relevant. So again, I think it's something that has to do with helping people understand the impact of what they've done and instilling a moral courage that gives a spine of steel and allows people of faith and their leaders to stand up for what they know is right and to realize that it is unloving not to do so at this point. People are being harmed and families and generations are ravaged as a result.
Allison?
Thank you, Mr. Chairman. Kristen, thank you for your really inspiring remarks today. You have blessed all of us, and we're grateful. You began with Solzhenitsyn, and thank you for reminding us that he stood not just against government, not just against communism, but against culture as well. And I'm wondering how can we better sort of equip and empower the next generation to cherish the First Amendment and the freedoms it protects? Because I do worry with all of these decades and decades of court cases and assaults and individuals that have been put through the ringer. I worry about the next generation and their commitment to continue the fight. So I'd just love to hear your thoughts on that.
I think for me, we talk a lot. I mean, we've given our lives to the study of the law and advocating the law. Kelly has as well. And it's a critical endeavor. but in some ways it feels like you're putting your finger in the hole of a dike. If the next generation doesn't appreciate these civil liberties and doesn't appreciate the fact that there's a higher power, and what it looks like to believe that not everything has to do with us, we're part of a bigger story. In doing that, I think that that work starts, of course, with constitutional literacy, and there are groups that are engaging in that, and this commission could recommend that the federal government do more to help with constitutional literacy, which teaches human frailty and human dignity, limitations of powers. We cannot have a robust civil society without a limited government, and there are profound reasons that have to do with correct human anthropological reasons for why we need that. So that is an important piece, I think, constitutional literacy and an appreciation of the First Amendment. The second thing that I would say, and has been touched on here, one of our cases was the Drummond case, which involves St. Isidore. We have to expand choice. There will always, first of all, be parents who will send their children to public schools. They just will. And that's why Beckett's Mahmood case is so important and why we must continue to support those efforts to have opt-ins, opt-outs, to give parents authority and transparency in the classrooms. But we also must ensure that religious schools, and First Liberty has done a good amount of work here, as have we, on ensuring they have autonomy in how they're operating and that they can operate consistent, whether it's a Catholic school, a Jewish school, a Muslim school. And lastly, educational choice when it comes to charter schools. And I believe that that case is going to come back up in a different form to the U.S. Supreme Court. But we need more state officials and more people that understand what's at stake and are willing to pass laws. All of these laws that go to the U.S. Supreme Court, they come from state and local levels. So we all have a role to play in this. And then lastly, and I promise I'll be quiet after this because this is what I'm most passionate about, which is this happens at our kitchen tables. It happens with our children. The highest call we can have is the call of being a father and a mother and influencing the next generation. And if we raise them in our faith and we raise them to respect the dignity and other people and that they are made in God's image and raise them to understand the Constitution, then the work we're doing now is going to endure. And that, I think, is truly inspiring and something this commission can also emphasize in its report to the president.
Are there any other questions? I'm going to finish with three quick ones. First of all, I was going to mention this earlier when I think it was Mark Hall who talked about school choice, and I didn't want to elongate it. But, and I'm not underscoring Texas, we just came out of a 140-day session, so we passed a lot of legislation, but we passed the largest school choice launch in the history of the country, $1 billion for 100,000 students. But I want to say this, and this is not a plug for the person who appointed me chair or any of us, but if President Trump had not engaged in the state of Texas in 15 elections, taking out those who opposed it, we would not have school choice in Texas today. And that is one of his it will be one of his many legacies that he has fundamentally changed the direction of education in the country by supporting school choice in every state. So I thank him for that. Question. They're talking about one big, beautiful bill over at the Capitol. Is there one big, beautiful case that would solve this? Because, and I say that in looking at Roe versus Wade, there was one case, the Mississippi case, that solved that problem, returning it to the states. Or is it this long road of having the Supreme Court take more cases, more briefs, the Department of all the things that you've recommended? Or could one big, beautiful case address many of these ills?
Well, these are the professors, but I will tell you my viewpoint is I think that I don't think that there is one big case or one big bill that can do that. First of all, the Supreme Court rule moves incrementally, and there are a number of religious doctrines involved, and I think that in many ways we begrudge that it moves incrementally in some respects, and in others we should be very thankful that it is thoughtful in how it is deciding these cases. I think there are a number of cases, though, that can be brought involving educational choice, the inclusion of religious schools and charter school programs, and things like that. And that requires local officials to do what they do, and that requires people to help those local officials have the courage to do what they do, because law and culture moves hand in hand. I don't believe one is exclusive of the other.
I agree with Kristen. So I also work on the Second Amendment, and we've had big Second Amendment cases, Heller, McDonald, Bruin, and the lower courts resisted. And I think even if you had one big, beautiful case that overruled Smith, overruled Lemon, lower court judges are stuck in their ways, they'll still resist. And it might take a generation to extirpate these cases. So it will be, as Kristen said, a cultural change and a judicial nomination change, and not just a change of one big, beautiful precedent.
We've touched on a few of the types of cases that would be helpful, or I'm hopeful that we'll see in the future. I think another one that we didn't mention is that the Supreme Court ought to overrule Bernie. That was the case where the court struck down half of RFRA, the half that applied to state and local governments, whereas Kristen's talking about a lot of these threats come from. Michael McConnell and other scholars have written about how that was a gross overreach of judicial power, and a misinterpretation of the original meaning of Section 5 of the 14th Amendment, and an area where we should encourage political actors like Congress to want to be more protective of religious exercise. So that's another area I would point to. I wish there was one silver bullet, but I do have to say for the Supreme Court that I think our precedent has never been more protective of religious exercise, because even though we did have robust religious exercise protections after Barnett and leading through the 1970s, for a long time we didn't have very good Establishment Clause precedent. And so, of course, there's always room for them to do more, and we would like them to move quickly because we're impatient, but I just want to give credit where credit's due that they're doing a lot, and we're lucky to have a Supreme Court that cares so much about this principle.
Maybe they were watching today. I don't know what their Monday was like.
They're not watching me.
Yeah. So lastly on that, with Roe v. Wade, they returned it to the states. Why doesn't the court return these issues to the states? Because wasn't that our founders' purpose? And let the states decide all of these?
Well, so we learned that the states were not very good at protecting religious exercise. We learned that in part, that was part of the motivation for the 14th Amendment. The states were violating not just religious exercise, but freedom of speech and other due process rights for a number of Americans, newly freed slaves, but also just all Americans. And it was something that Bingham talked about during the Reconstruction era, that the Fugitive Slave Act, a law that was, by the way, neutral and generally applicable, was being used to prosecute religious believers who wanted to try and just offer food or aid to fleeing slaves or recently enslaved people. And they were being prosecuted for doing so. And this was something that Bingham said was, the 14th Amendment will make sure that those state and local governments can't engage in that sort of activity anymore. It will protect that sort of religious exercise, which is further evidence beyond founding era, but Reconstruction era evidence of why robust religious exemptions, even in the face of neutral and generally applicable laws, were understood to be protected by our Constitution.
Kristen, go ahead, Kristen.
I do want to just emphasize, too, that in many of our cases, well, pretty much almost all of them at this point, we find the relief from the Supreme Court. The issues that we're having are bubbling up at the local and the state level. So I would be careful to try to remove that jurisdiction or somehow suggest that the court hasn't been protective. They haven't been protective enough, though.
And
Well, I wanted to ask that question, so go ahead.
one small thing I'll add, I do think that the court needs to set like a minimum protection, but I think, and Bernie's an example, they should not slap down legislatures who are trying to go above what they view as the minimum, which is precisely what they did. And there are some states like Texas that are going above and beyond, and we should encourage that sort of political protection. It's a good thing in our democracy.
So I'll close with this, and to the audience, thank you. You've been very patient and very respectful, and to all the committee members. It was as if we had done this before, but this was the first gathering of the team, and I thank all of you for the time you've given. So I don't know what the name of the report will be, but the first name in the hat, because it's a long time away, 10 months, 11 months, but one of the names that must be considered, I think, members, is we are the last Western country in the world protecting religious freedom. That's a pretty powerful statement, and makes me even more thankful that the president said, go forth and do this. So thank you. Please give our witnesses an applause. Thanks again to the Museum of the Bible. Thank you for being here. Our next hearing will be September 8th, I think is the date, and we'll notify you. This hearing is adjourned. Thank you.